We're going to dive deep into the fascinating mechanics of constitutional law. We'll be looking at exactly how the Philippine Supreme Court balances our individual rights against the really vast, sweeping powers of the state. Okay, let's jump right into this because we have some incredibly rich legal concepts to unpack today. Now, you might be wondering, how does a court actually decide if a law is unconstitutional? It's a massive question, and it gets right to the heart of how our society operates. How does the highest court navigate these high-stakes disputes to determine what is legal, what's fair, and what completely crosses the line? When a huge controversial law is passed, or a high-ranking official's position is suddenly challenged, what tools do judges use to make those massive calls? So, here's our roadmap for this explainer. 1. The power of judicial review. 2. Due process and vague laws. 3. Strict scrutiny versus construction. 4. Quo warranto and jurisdiction. 5. Equal protection and action. And 6. The balance of power. Let's get started. Section 1. The power of judicial review. Guarding the Constitution. You see, the Constitution defines judicial power not just as an option, but as an absolute, mandatory duty for the courts to settle actual controversies. They literally can't just sit on the sidelines.
But here's the thing. There's a foundational rule courts invariably train their sights on whenever a legislative act is under a constitutional attack. They proceed with, well, extreme caution and restraint. And why is that? Because out of respect for their coordinate branch, the legislature, courts must assume that lawmakers are completely conscious of the borders and edges of their plenary powers. They operate under the assumption that the law was passed with full knowledge of the facts to promote the welfare of the majority. So, striking down a law? That is always a measure of absolute last resort.
Moving to Section 2, Due Process and Vague Laws, the Anti-Plunder Law Challenge. What actually happens when a law is accused of simply not being clear enough? A perfect real-world illustration of this is the high-profile challenge to the anti-plunder law in the Joseph Estrada case. Which brings us to the void for vagueness doctrine. Sounds like heavy legal jargon, right? Let's break it down. This doctrine protects you and me by making sure a law gives fair warning. If a law is so vague that folks of ordinary intelligence literally have to guess at what it means, it's unconstitutional. And there are two big reasons for this. First, it fails to give fair notice of what behavior to avoid. And second, and honestly perhaps more importantly, vague laws leave law enforcers with unbridled discretion. That naturally leads to arbitrary and discriminatory enforcement. It essentially becomes an arbitrary flexing of government muscle, and we definitely don't want that. And then you have mens rea. This is the constitutional requirement of a guilty mind or guilty intent. In the Estrada case, some argue the anti-plunder law totally threw this substantive due process requirement out the window. But here's why that's dangerous. Eliminating the need to prove a defendant's guilty intent radically changes the scales of justice. It eases the prosecution's path to conviction way too much, and it strips the defendant of common law protections against being punished for a simple, innocent mistake. This actually ties back to a really profound philosophical point referenced during that Estrada case, captured beautifully by John Stuart Mill. He argued that individual spontaneity must be allowed to flourish with very little regard to social interference. It highlights that sacrosanct line protecting individual liberty. Even as we grant the state vast powers to keep order, there simply must be a protected sphere of individual spontaneity where the state absolutely cannot tread. That right there is the very essence of what due process seeks to protect.
All right, Section 3, Strict Scrutiny versus Construction, Analyzing the Law. Let's look at how the court actually tests these laws and clear up a super common mix-up between two completely different analytical tools used by judges.
It really comes down to strict construction versus strict scrutiny. Strict construction is a rule of legal hermeneutics. Basically, it's all about meticulously parsing the text of a criminal statute to figure out exactly what the legislature intended. Strict scrutiny, on the other hand, is a totally different standard of judicial review. It's used when fundamental freedoms, like free speech or religion, are at stake. The court made it abundantly clear that criminal laws, like the plunder law, are judged by strict construction, not strict scrutiny. You just can't mix and match these tools. They do entirely different jobs.
Similarly, we have the overbreadth doctrine. Think of it like using a massive net to catch a few fish. The government can't use that massive net if it also sweeps up constitutionally protected freedoms in the process. But again, the courts clarified that overbreadth, along with vagueness, is an analytical tool primarily developed for testing First Amendment free speech cases on their faces, meaning the law is invalid in all its applications. They typically do not apply this way to criminal statutes, which are almost always judged as applied to a specific defendant's actual conduct. Moving right along to Section 4, Quo Warranto and Jurisdiction, resolving questions of title. To understand this one, we're going to look at the mechanics of the Maria Lourdes Sereno case, which gives us a really fascinating look at how the Supreme Court exercises its original jurisdiction.
So what the heck is quo warranto? Well, it's a specific legal proceeding used to challenge a person's right to hold a public office. The absolute crucial distinction to make here is between quo warranto and impeachment. They are entirely separate mechanisms. Impeachment deals with removing a validly appointed officer for specific high crimes committed during their tenure. Quo warranto, however, asks a much more fundamental question. Were you even legally eligible to hold this office in the first place?
To anchor their jurisdiction to hear the quo warranto petition, the court relied on this famously blunt logic from the late U.S. Supreme Court Justice Antonin Scalia. If it is in the Constitution, it is there. If it is not in the Constitution, it is not there. It's that simple. The Philippine Constitution explicitly grants the Supreme Court original jurisdiction over quo warranto cases. It notably does not say, except for impeachable officers. Therefore, the judiciary literally cannot abdicate its constitutionally imposed responsibility to resolve a question of eligibility, regardless of the political heat or public indignation surrounding the whole thing.
Section 5. Equal protection in action, from liquor laws to labor unions. Let's step away from high-level government offices for a minute and see how these legal pillars apply to everyday society. Specifically, we'll look at how equal protection and administrative jurisdiction play out in the real world. We always hear about the Equal Protection Clause, right? But equal protection does not mean the law has to treat every single person identically all the time. Actually, the historical Karyat case laid out a crucial four-part test for what we call reasonable classification. If a law targets a specific group, it absolutely has to meet all four of these requirements. 1, it must rest on real substantial distinctions. 2, it must be relevant to the law's purpose. 3, it can't just apply to conditions existing right now. And 4, it must apply equally to everyone within that defined class. If it hits all those marks, the classification is totally valid and equal protection is preserved. Let's apply this structured thinking to labor laws, looking at a dispute involving the diaconal union election. The law categorizes labor disputes very clearly. An intra-union conflict is an internal fight, say members of the same union arguing over an election. An inter-union conflict is a battle between two completely different unions. The law grants the Bureau of Labor Relations, the BLR, original and exclusive authority over these specific organizational disputes. This just ensures they are handled by specialized bodies who know exactly what they're doing. Which leads us right into a fundamental procedural rule, the exhaustion of administrative remedies. Normally, you gotta climb this ladder step by step. You can't just skip ahead and run straight to the Court of Appeals. But here's the catch, and the Diacono case really highlighted this. There is a vital exception. If following these internal steps would be utterly futile, or if it would practically amount to a denial of justice, like, for example, if a union committee just disqualifies candidates the day before an election without any due process, well, the victims are allowed to bypass the internal union remedies and seek immediate outside intervention from the BLR. So the law is rigid, yes, but it is definitely not blind to injustice. Finally, Section 6, the balance of power, why this matters. Let's bring this whole narrative full circle. Why does understanding these incredibly dense, complex legal doctrines actually matter to you and me? Because these rules are the literal blueprint for protecting fair play in our entire society. Look, whether we're talking about a president facing a plunder law, a chief justice dealing with a quo warranto petition, or just a union member fighting for a fair election, 4 principles remain the ultimate safeguard. The law must be reasonable, enforced via regular procedures, prescribed in harmony with legislative powers, and applicable alike to all citizens. Due process is the absolute embodiment of the sporting idea of fair play. It is our ultimate shield against the arbitrary flexing of government muscle. And that leaves us with this final, provocative thought. We rely entirely on the judiciary to use these exact mechanics, strict construction, the vagueness doctrine, the test of equal protection, to ensure that the state doesn't overstep. But man, it's an immense, heavy responsibility. The courts must strike down unconstitutional laws, yet they simultaneously have to show restraint and deference to elected lawmakers. It's a delicate, brilliant balance. So, when the lines of power inevitably blur, who guards the guardians? Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll see you next time.